The big case of the term, it's already been decided. John Cruden alluded to it earlier today. This is the Clean Water Act case. This is where you can bring challenges, what court you can bring challenges to, the waters of the United States, the WOTUS rule. Because when EPA promulgated the WOTUS rule on June 20, 2015, it wasn't clear where you bring that lawsuit. The relevant provision of the statute, section 509, singles out certain kinds of situations when you have to bring it to the Court of Appeals in the first instance, including when EPA is approving or promulgating any effluent limitation or issuing or denying any permit under section 402. The question is whether the WOTUS rule was either E or F, whether it was the same thing as approving or promulgating an effluent limitation or the same thing as issuing or denying any permit. Then you have to bring it in the Court of Appeals. Other than that, it doesn't say what you have to do, which means back to district court as default. The Clean Air Act is completely different. The Clean Air Act provides great guidance in this area. Clean Air Act basically says you got to bring all those kinds of things in the Federal Court of Appeals in the first instance. And certain subset of it, you got to bring them in the DC Circuit only. But the Clean Water Act provides no such equivalent guidance. And so when this thing is enacted, June 29, 2015, right, lawsuits are brought everywhere. These are lawsuits brought in different district courts around the country. And EPA and the Department of Justice are like, it's like whack-a-mole. Everywhere they go, they're trying to whack out these lawsuits being brought every which way in district courts around the country, and cases are being brought in Court of Appeals around the country. It's a mess when this happened. But finally, the Sixth Circuit said, we think we have jurisdiction, in a completely fragmented opinion. It was hard to see what the rationale was. They decided that National Association of Manufacturers sought Supreme Court review in the case, and the court granted it. So the court granted review. The argument was heard this fall, and the court decided the case on January 22nd. And the court said the WOTUS rule falls outside of the Court of Appeals jurisdiction. You got to go to district court. It's not very good, sensible policy to have these things get sent all over the country to district courts. But, it's what the statute says. And that's pretty much what the court says. It's a unanimous opinion by the Supreme Court. The court said it doesn't fit E. It's not an other limitation. That's what the language says, other limitation. The WOTUS rule is not an other limitation. It doesn't fit. And the government says, well, it makes sense to do it there. It makes sense. Look, what makes sense isn't what the law is. They say it's not F. It's not approving or denying a permit either. Again, it's not that. The government has to ignore it, and they say you should do a functional interpretive approach instead of language. What's interesting about the government's approach is, actually, the government had some pretty good precedent in favor of this kind of approach based on Supreme Court opinions written in the 70s and the early 80s, before the whole court became textualist. The court now, they look at language now. They don't like practical effects as much. They don't like functional, let's see what makes sense. They're not willing to do that anymore. Almost all of them are much stronger textualists. It's really had a huge impact on everyone's thinking in this area.